All rise. The Court of Appeals, Division 1 is now in session.
Good morning. I think we're still morning. Yeah, you may be seated. Thank you. We are here on our case number 1CACV150504, McLeod versus Deutsche Bank National Trust Company as trustee. Counsel, as you both know, we allow 20 minutes aside for the argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it because the clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you if you would, when you approach the podium, recite your name and the name of your client. We have read the briefs and we've studied the record at some length in the case. We've also discussed the case in our conference. So with that, you may proceed.
Good morning, Your Honors. Robert Norman for the appellant, Deutsche Bank as trustee. May it please the court. The appellant, Deutsche Bank as trustee, requests that this court direct the trial court to vacate a 2008 default judgment, or, in the alternative, to clarify that this judgment does not prevent Deutsche Bank as trustee from foreclosing on its first position lien interest. The appellant, Deutsche Bank as trustee, is the first position lien holder. That debt, as we sit here today, exceeds $1.4 million. That debt resulted from a $776,000 cash out refinance loan that the McLeods obtained in 2006. Now, the McLeods were pro se through a large part of the underlying trial court proceedings, but they are extremely sophisticated pro se plaintiffs. As mentioned to Judge Talamonte at the March 14th, 2014 status conference, Mr. McLeod himself and his company had been involved in at least 30 different lawsuits in the state of Arizona. In this case, in year 2008, the McLeods defaulted on their loan and foreclosure proceedings were commenced. The McLeods then filed a wrongful foreclosure type lawsuit that had a variety of different claims, loan origination type claims, wrongful foreclosure type claims. They sued 10 different entities. They brought 12 plus different causes of action. The litigation did last roughly 6 years for a variety of reasons, including the number of defendants, the number of claims asserted, various settlement efforts by the parties over those years. Now, again, the focus of this appeal goes back to the trial court's error in interpreting that this 2008 default judgment somehow applied to the Deutsche Bank trust, which actually timely answered and entered an appearance 2 months before that default judgment hearing. To go on, the 2008 default judgment is against a non-existent entity that was specifically labeled by the McLeods as a New York LLC. That is how it was identified in the caption, and also referenced in the complaint. I'd like to talk about the complaint because I think that really frames an important part of the beginning of this case and what transpired for the years to come. In this complaint, the McLeods mentioned, or identified, I should say, the Deutsche Bank Trust, the DBNTC entity that did timely answer. They mentioned that entity 10 different times, at least 10 different times, as being the beneficiary or the lien holder. This purported Sabre New York LLC entity was mentioned 0 times in the operative complaint as being the beneficiary or lien holder.
I'm a little confused by your reference to the Sabre entity in the complaint as an LLC. I read it here as Securitized Asset-Backed Receivables LLC Trust 2007 NC2. A trust, not an LLC, although
on the cover page, the caption of the complaint, it is identified as a New York LLC entity, is what I was referring to, Your Honor.
I see. It's identifying as a New York. Okay, I get it.
Correct. And then which leads into the interpretation by the defense of the allegations. What are the allegations? What are they saying about these various roles, these various entities? Paragraph 60 of the verified complaint, the McLeods reference HOMAC as the alleged servicing agent for Deutsche Bank. They don't say that HOMAC is a servicing agent for this Sabre LLC entity. Paragraph 70 of the complaint, they note that Tiffany and Bosco, the foreclosure trustee, was the trustee for the alleged beneficiary, Deutsche Bank. Again, they don't say Sabre. Paragraph 76 of the complaint, the McLeods say they're seeking proof of assignment to Deutsche Bank. They don't say Sabre. Paragraph 81 of the complaint, the McLeods complain that the substitution of trustee references Deutsche Bank. They don't say this Sabre entity. This goes on, Your Honors, in paragraphs 141, paragraph 170. We then get to the exhibits. The exhibits, which were primarily the substitution of trustee, the notice of trustee sale. If you look at those documents, they all identify that Deutsche Bank National Trust Company is the trustee for this beneficiary. Not a single mention in that complaint to suggest that they were contending the Sabre LLC entity was the beneficiary. Fast forward a few months, an answer is filed for Deutsche Bank National Trust Company, September 30th, 2008. Go a month forward to October, the end of October. There's a status hearing where the parties are discussing the pending foreclosure sale. Prior counsel appears. Prior counsel agrees. There's a mutual agreement to cancel the foreclosure sale. That prior counsel that appeared for Deutsche Bank National Trust Company, appeared for HOMAC and some of these other HOMAC entities, which was the prior servicer. The Sabre LLC entity is nowhere in existence. You now get to the November 24th default hearing, which lasted a total of about 8 minutes. There's not a single reference to the Deutsche Bank trustee entity at that hearing. Mr. McLeod, who was present, testifies, talks about not receiving TILA disclosure statements, suggests to the court that this Sabre entity is the last person that owns the loan, which is completely different from the operative complaint, also completely different from the hearing that occurred 30 days earlier before a different judge, where the actual parties were asserting and protecting and defending their rights. After this 8-minute hearing, the commissioner approves and signs off on what was a form judgment presented by the McLeods. There was no substantial evidence presented that this lien had been paid off. No evidence that this loan was going to be paid off. Even assuming, for argument's sake, that there was some type of a TILA violation, which we don't agree there was, there would still have to be a retender of the debt. You don't get the property for free, especially a property worth nearly $1 million. Some of the other arguments, Your Honors, that we set forth in our briefing is that despite the fact that the trust, Deutsche Bank, did appear and aggressively actively defend itself throughout these proceedings by attending hearings, by working through discovery issues, and there were discovery disputes, by setting forth this Rule 16 report, which was ordered by Judge Talamonte, that listed dozens of issues, dozens of disputed facts to still be addressed. Now, I personally was involved in working on that Rule 16 report. I didn't want there to be so many issues, so many things to address, but we had no other choice because we had an operative complaint with 12 claims to deal with. In that Rule 16 report, I believe it was number 12 was an item specifically identified by the McLeods as being whether or not this 2008 judgment would apply to the Deutsche Bank Trust. Obviously, we disputed that. That topic came up for discussion with Judge Talamonte at a few hearings. Judge Talamonte earlier in the case had indicated that will be an issue to be decided based upon law and evidence. The appellant never got the opportunity to have that law and evidence weighed or considered. Instead, there was this erroneous result 2 weeks before trial, a complete 180-degree decision by Judge Talamonte to sua sponte determine that he believed that this judgment that doesn't mention Deutsche Bank as trustee, irrespective of the fact that Deutsche Bank appeared ahead of time, and all of the reasons I just articulated, he believed that that now precluded the Deutsche Bank Trust from foreclosing.
So let's talk about your 60C motion.
Yes.
One of the arguments that you made was that the judgment against the Sabre entity, the default judgment, was void because the court lacked personal jurisdiction over that entity. What are the reasons that support that motion?
Your Honor, I believe the focus or the intended focus of that motion and the arguments to the court was, again, that the Deutsche Bank Trust entity had appeared before this default judgment and that it was aggressively defending its case. The arguments as to no jurisdiction would be because this is a non-existent entity, a purported New York LLC that doesn't even exist. When you look at the proofs of service filed by the McLeods that relate to this non-existent entity that go back to August 2008 and November 2008, when you actually look at the declaration of service, that there's extreme confusion created by the McLeods there.
Well, I don't know. I would suggest that whoever accepted the service may have had a role in causing some confusion. Wilmington Trust Company did accept service for securitized asset-backed receivables LLC Trust 2007 NC2. Service was accepted on that defined entity.
Your Honor, these are registered agents that just receive paper. It's not for them to decide at that moment to reject that paper. They receive that, and if there's no entity to be assigned to, who knows what happens with it? And I believe that's potentially what happened in this case. But regardless of that, as I mentioned, the Deutsche Bank Trust, which was framed in the complaint as being the beneficiary, appeared, answered, agreed to cancel the foreclosure sale, and then proceeded with litigation for 5 years, even a few years while Judge Talamonte was assigned to the case. So to then have this default judgment, which are obviously highly disfavored, retroactively applied, was an extreme taking away of our due process.
I think the argument that the McLeods make is that if Deutsche Bank was appearing as the trustee, now it wasn't served as the trustee, it was served on its own independent entity. But if it was appearing as the trustee on behalf of the trust, then it should have made those arguments on behalf of the trust at the default hearing, rather than just failing to show up.
Your Honor, I think going back in time, and that's why I began the argument with setting up the context. Deutsche Bank files their answer before the default hearing. Deutsche Bank, the complaint only talks about Deutsche Bank being the beneficiary. 30 days later, Deutsche Bank attends a court status hearing where the parties discuss the case, the foreclosure sale, that HomeEc was the servicer, Deutsche Bank's the beneficiary. The foreclosure proceedings are put on hold. I could see where there was no reason and why prior counsel didn't appear at this hearing for some non-existent New York LLC. For all intents and purposes, he could have believed that that was perhaps a depositor entity, which has a similar sounding name. And in handling these types of cases, I've handled these types of cases for a number of years, I've seen different entities be named. But
Could the real name of the trust that owns the mortgage, whatever that is, let's just call it the trust, could the trust have been served and sued in its own name?
I don't believe so. I don't believe so.
And why is that?
Well, going back to case law across the country, going back to the Arizona Trust Code, going back to the fact that this is a common law trust, it's contractual in nature, we don't believe it's a business trust, everything is done through the trustee. That's why the foreclosure notices, the assignments, when a judicial foreclosure action is filed, it is done by the trustee in the trustee's name as the trustee for the trust. That's how the deal is set up. That's how the pooling and servicing agreement is set up across the country. But again, what's so challenging here, or maybe frustrating is a better word, is that the trust was defending its interest. It was, I believe, an abuse of discretion to say that this Sabre 2008 judgment, which doesn't reference Deutsche Bank as trustee, doesn't reference the actual lien, doesn't reference anything of those items, to then be later applied to some other entity when you're just 2 weeks away from a trial where the McLeods themselves say they want 27 witnesses, hundreds of documents to prove up these claims. The other thing to consider is, even with respect to this, to the 2008 default judgment, is our motion to set aside that for lack of any substantial evidence. I believe that was the Rule 65 motion. At an 8-minute hearing, there was nothing presented to the commissioner to justify a permanent injunction against Deutsche Bank as trustee for this trust, an entity that had appeared, an entity that's got a valid loan with a debt more than of $1 million, an entity that hasn't received a mortgage payment for now 9 years, has advanced taxes and insurance on this property, all the while because of this extreme confusion and complexity created by the court, by the McLeods, which apparently led to some frustration or other issues developed in the air. Your Honors, I recognize the court also did request supplemental briefing on some of the trustee issues. I don't have anything specific to add on that beyond what was set forth in the briefing. I would like to reserve the rest of my time for rebuttal unless the court has any other questions at this time.
Sure. Thank you.
Excuse me. Good morning. I'm Beth Benson, and I represent the appellee. I have Mr. McLeod, one of my clients, sitting here with me. May it please the court, this appeal is not about retrying a case that already happened. It's about the integrity of a final judgment entered in Arizona in 2008 that was never timely challenged. Deutsche was served as a separate defendant along with Sabre LLC Trust, which is a real entity, at least according to the pooling and servicing agreement that wasn't before the trial court, but that Mr. Norman has presented to this court with a supplemental briefing. There's a depositor entity that is an LLC with that structured asset-backed name, and then there's also a trust.
Was the trust is
all were served.
Why? But as Mr. Norman points out, the Sabre LLC trust entity was identified in the complaint as an LLC, not as a trust.
They call it in the pooling and servicing agreement, the Sabre LLC Trust is the name of the trust. Then there's the Sabre LLC entity that is the depositor.
Right, and
separately.
which one of those was sued in the complaint?
The trust.
But as Mr. Norman points out, it identified, the complaint identified this trust as an LLC, not as a trust.
But that's how it's self-identified
No.
in the PSA.
I don't think it says it's a LLC. The depositor is the LLC.
The
But
depositor
there's
is
a
the
separate
LLC.
trust,
Correct.
which is a trust, not, as the caption says, an LLC.
If you look at the notice of trustee sale and the documents recorded in Arizona related to this foreclosure sale, the name was often presented in different ways. For example, in one of the notices of trustee sale, they identified current beneficiary as Deutsche Bank / Sabre 2007 NC or what have you.
But the documents are the documents.
Correct.
I mean, the trust document is the trust document, the deed of trust.
But I'm sorry, go ahead.
I'm suggesting that for purposes of determining whether the Supreme Court had subject matter jurisdiction,
Right.
personal jurisdiction, I should have said, to enter the default judgment against a trust that held the mortgage. I think we look at the caption and we look at how that entity was served.
The entity was served, the affidavit of service was filed, there was no objection to service. As you know, in Arizona, that's given great weight. The default hearing was set and rescheduled. The attorney, Kevin Hahn, the initial attorney for the defendants, purported to represent that Sabre entity, Deutsche, and several of the other servicers. He knew of the default hearing and chose not to attend. That's what happened. And then clearly after that, Deutsche did file an answer, but it did not include that Sabre entity that had been a defendant. And as for personal jurisdiction, well, when its name is appearing on recorded documents to foreclose Arizona property and nobody contests the personal jurisdiction of the court at that time.
But Deutsche wasn't sued as the trustee.
Right, because Deutsche had presented in its PSA that Deutsche Bank National Trust Company, not Deutsche Bank National Trust Company as trustee.
But
later, it chose to ask Judge Talamonte to change that name as sort of a misnomer. However, but if we're looking at the function of what Deutsche Bank was there to do, if it was the trustee of this trust,
was where to do?
In court defending, which it did for several years, and it had plenty of time to move to set aside that default judgment for lack of capacity, for improper service, or to file a summary judgment motion, or to ask for any kind of relief. It chose a dangerous course, which was just to ignore it. It made its own decision that this is a jumble of names, which it really wasn't a jumble of names. It appears in their documents filed at the SEC. In function, if Deutsche was trustee of this trust, and its trust was implicated by this order with Rule 54B language, then it should have done something then, and it didn't, as you can see. I don't think that deprives the court of jurisdiction. I think there was personal jurisdiction over that entity. The service process was proper. The court has subject matter jurisdiction under numerous statutes related to real property in Arizona, related to recorded documents in Arizona. There were specific contacts with the state of Arizona by this trust in purporting to take this property. There's case law that supports that acting as a beneficiary under a deed of trust where a notice of trustee sale is recorded is a purposeful availment. If there weren't even...
But we're not talking about Deutsche here. We're talking about the entity against which the default judgment was obtained. If that judgment was void, either because there's no entity by that name or because the entity by that name cannot be, as a matter of common law, be sued in its own name. So if the court, if that judgment is void for lack of jurisdiction, is there a timeliness requirement under 60C4?
Rule 6, that's the void exception is the only one without a time qualification, and we concede that. However, I would just direct the court to an error in a judgment, like an error of name, everybody knew what trust we were talking about. Deutsche knew, and it could have made that argument. I don't think an error in judgment, as Cockerham, Arizona Supreme Court, does not make it void for lack of jurisdiction. Like we often confuse jurisdiction. There have been extensive opinions, and I cited in my brief, but that, it's not synonymous. Even a lack of capacity is not synonymous with void to deprive the court of jurisdiction and to abolish a final judgment in Arizona, which we're to give solemn import to. And it's a strong policy to, obviously preserve the finality of judgments in Arizona. Can
a common law trust be sued in its own name?
Yes.
What's the authority for that?
I listed several cases where it occurred in Arizona. Are you talking about in Arizona? Or are you talking about in these? I've looked at all the New York and Delaware cases concerning these specific kind of animals, these weird securitization trusts, which are different types of trusts than just a general common law trust.
I think the cases that were in your supplemental brief were actions among the parties to the trust, the depositor versus the trust, or the trustee versus the depositor, and so forth and so on. What I'm wondering is whether a third party that ostensibly has a claim against a trust may actually sue and serve a common law trust without instead proceeding against the trustee as trustee of the trust?
I think that's a different scenario than what occurred here. The cases that are concerned with when a trustee are when a trustee is not also named. So there's no notice. There's nobody there to protect the rights. And that wasn't the case here. The trustee was there.
Although Deutsche wasn't sued as the trustee, it wasn't identified as the trustee. I read the complaint months ago, I don't think it's mentioned in the complaint that it is the trustee of the trust.
It complained at some of the hearings, and there were several over the years. Deutsche said, I represent Deutsche as trustee, and finally the caption was changed by Talamonte as to that name.
Years after the default judgment was obtained.
Correct. But Deutsche had always, it was saying it was the trustee for this trust. It knew that this trust was implicated by this judgment, and it did nothing. I mean, Deutsche is a pretty sophisticated defendant. It had a generous procedural toolkit. It had 7 lawyers over 6 years against these pro se plaintiffs. And rather than confront the issue directly, hey, there's a judgment with Rule 54B language against the trust that we say we represent as trustee, you know, it was on Deutsche. But also, a mortgage-backed securitization trustee, it's different in a common law because it has limited ministerial type of duties. It doesn't have these broad fiduciary duties that you think of. And also in this case, as in the cases I tried to show you, when those common law trust principles are espoused, such as Mr. Norman's arguments here, it's because there's a danger of no notice to trustee or to somebody with authority to act. You know, to go to Judge Talamonte and make that argument, hey, we're the trustee, this is, you know, this judgment's here, we need to do something about it. Or what does this mean? Even earlier, I mean, there were multitudes of opportunity that would not, to address that error. I don't think it's an error that amounts to deprive the court of jurisdiction years after the fact. I think it's a capacity issue conflated with a jurisdictional issue of the kind that Cockerham, the Arizona Supreme Court, and Cockerham and other cases have talked about. That we have to be very careful not to conflate capacity or error in a judgment with void, especially under 60B4, because it's the only no time limit exception, and it's to be construed strictly, and in the facts of the case are to be construed, you know, with deference to the trial court, who heard it, who looked at it, had many hearings, expressed frustration. We've cited bits of the transcript.
What about the fact that the Rule 16 pretrial conference statement identified whether Deutsche Bank as trustee is bound by the default judgment as an issue to be tried? What do we make of that vis-a-vis the court's sudden announcement that, well, never mind about that?
I think that what happened is there were so many changes of attorney with Deutsche, and Mr. McLeod was trying to write this pretrial order without guidance, and so Judge Talamonte was trying to help them out to get that consolidated and in proper form for trial. And a year prior, in one of the transcripts, there was a hearing where he said, look, no, I think that's a final judgment. I think that's a big problem to get around. That's what Judge Talamonte said. Deutsche wanted to file a very late summary judgment motion, and the court had already given them several extensions to do so, and they didn't. So he said no. we'll take any issues to trial. So what you had was a pro se plaintiff working at the last minute on a Rule 16 order without being able to get even final edits from the opposing counsel. I think I'm correct on these facts because I wasn't involved in it, and got some last minute changes and they submitted it.
But under the theory of the appellee's case, it was game over with entry of the default judgment. Why did things continue for another 6 years?
There were other claims in each of those parties, like the claims against the loan servicers. They settled out and disclaimed an interest as part of the settlement. They, in some cases, I think, gave an affidavit to Mr. McLeod saying we don't claim any interest in this subject property. But Deutsche was still claiming an interest in the subject property. So Deutsche was the only defendant left.
Well, I think that's my point. Why did the case continue against Deutsche if, by your client's account, there was no point in it after entry of the default judgment?
Right. I think that my client may have suffered some confusion over what to do next as a pro se plaintiff. Do I just dismiss? And I have to correct a misstatement that was an aside, but his business was involved in 3 lawsuits. It was a cell phone business, not 30 lawsuits. He's not a sophisticated litigant. And I think it's difficult for lawyers who have looked at a lot of these PSAs to even decipher who the parties are, especially when you're receiving letters and notices of default from all sorts of different entities and saying all sorts of different things about who the actual parties are asserting an interest in that deed of trust. There were assignments to odd parties. There were demands for non-payment and notices of acceleration in different names. There was more than one notice of trustee sale, naming a different beneficiary. I think, it's easy as a plaintiff or homeowner to get confused over who is actually asserting an interest. So I need to name them. I'm going to name them as they've named themselves, whether that's erroneous or not. But the bottom line is all defendants had notice of that default hearing. They were represented by one common counsel who had actual notice and, record notice of it and chose not to appear and then chose not to have it set aside. With respect to revisiting facts that are to be perceived in favor of the judgment, of upholding the judgment in Arizona. We know service was accepted. We know that affidavits of service were uncontested. We know that there was no claim of no personal jurisdiction or lack of subject matter jurisdiction. There were nothing in the answer by the other defendants made compulsory counterclaims about lack of capacity of a related party. If you think of the trust as related, if you take Deutsche at its word that it is trustee of this trust and it's acting on its behalf with respect to this Arizona real property, and you know that there's this default judgment there, to do something about it. Rule 60C exceptions, especially 6, I think they also ask for Rule 60C6 exception, have to be made within a reasonable time. The case law shows even 2 years, 3 years not being reasonable. They're, rare and not easily warranted for that catch-all provision. I think this court so held recently in that Cal Extra case. So I would just encourage the court to consider that I don't think Arizona has a policy of wanting a whole musty box, Pandora's box, of 6-year-old default judgments being revisited by making a loose determination with respect to void versus errors of capacity or errors of wording in that judgment when those arguments could have been made timely.
All right. Thank you.
Thank you.
Thank you for your argument.
Thank you, Your Honors. I'd like to comment on a few of those points and obviously address any questions the court may have. Again, the operative complaint that we're talking about, as the court knows, identifies the Securitized Asset-Backed Receivables LLC entity as a New York LLC. The only other reference, I believe, to this defendant entity is paragraph 11. Again, it states that it's a New York LLC. I believe that puts parties on notice, which a complaint is supposed to do, that that entity has nothing whatsoever to do with being the beneficiary or the lien holder in this case. The notice of trustee sale that counsel referenced, which is a common document utilized throughout the state of Arizona and many non-judicial states, clearly identifies the full name of the trust. There is one section in the middle of the document where it identifies beneficiary, and it states Deutsche Bank / and then it gives the series number for the trust. If you turn over one page, Exhibit A, well, to the notice of trustee sale, which I believe was Exhibit I to the operative complaint, clearly indicates the full name for the trust acting through the servicer at that time, which is common for these arrangements, which was a home ec entity. Your Honors, there were some comments about giving the sacrosanct blessing to this default judgment not overturning. And I understand the general maxim there, but what's more important here is that it was a default judgment against a non-existent entity based upon misrepresentations to the court for a hearing that lasted 8 minutes versus 6 years of litigation. Deutsche Bank, who's identified more than 10 times as being the beneficiary and lien holder, Deutsche Bank appearing at a hearing a month before, explaining that it's the beneficiary, agreeing to postpone a foreclosure sale while they tried to work out this dispute. Many of these disputes years ago were resolved informally or with resolutions. Those were attempted here, but because of a refusal to do anything reasonable, it didn't happen. That led into the 6 years of litigation, everything that the courts talked about. A few other points to address with respect to the default judgment again, and the questions about, well, why wasn't the case over in the MCLEOD's mind? Well, because they knew that this was at best some judgment against a non-existent entity. They knew that the real parties in interest timely answered and were defending against, which I believe are completely meritless claims. If the MCLEODs so firmly believed that they had that final judgment, they could have moved to amend. They could have done something like that. I appreciate that the MCLEODs were pro se, but they are quite sophisticated. Mr. MCLEOD himself was very intelligent, had the business. Our research did show it was 30. That's also what we referenced to Judge Talamonte at the trial conference just weeks before our trial. Your Honor, even if it's talking about the jurisdiction issue again, the Deutsche Bank entity, DBNTC, which was treated as and identified as the beneficiary from the beginning stages of the complaint, it admitted and conceded to the court's jurisdiction and was ready to proceed. Again, this non-existent entity, we can't speak for because it's an entity that I believe doesn't exist, number one. And number two, even if it was the trust entity, I believe the restatement, case law across the country, New York case law, which governs this pooling and servicing agreement, all indicates that a trustee is the real party in interest to protect and defend, which I do believe the trustee did here. Your Honor, we touched on the equity arguments. I can't envision a case, well, I'm sure this court has seen many cases where equitable arguments are important, but they are extremely important here. $1.4 million loan, a cash-out refinance against nearly $1 million property. There was no real law, no real evidence ever presented to the trial court, either the commissioner or Judge Talamonte, to issue this order that just essentially eviscerates the Deutsche Bank Trust rights. that order should be vacated or at a minimum amended to clarify that the Deutsche Bank Trust, the appellant before you, is free to proceed with its contractual and state law rights to foreclose. Your Honor, I'm out of time. Thank you very much.
Thank you. Thank you to both of you for your briefing and argument. We'll take the matter under advisement and issue a decision in due course. Now we stand adjourned.